Let's see. Good morning, ladies and gentlemen. My name is Judge Cal Evans. This is your first appearance hearing, and I'll let you know what charges have been presented, what, if any, conditions of release are appropriate, and for the purposes of today's hearing, I'll appoint the Office of the Public Defender to represent you. If you'd like them to represent you in the future, please fill out an application, and we'll see if you qualify. Keep in mind their services are not free. It's $50 for the application, and then there is a service fee. And also, extremely important, please keep in mind everything you say is being recorded, both video and audio. So keep that in mind when you're at the podium. This is not your trial day. This is merely to determine conditions of bond or release, if appropriate. And with that, we'll call Ms. Linda Hay.
Man, Joe.
Judge, I have a probable cause argument.
Ms. Counsel?
At the very last sentence of this, Hay stated that she was unaware of the fact she needed to have a driver's license to operate her scooter under 50 cc's. And the law says that you don't have to have a license if it's under 50 cc's. So the officer was mistaken to arrest her.
State?
It doesn't say that it was under 50 cc's. It just says she didn't know that she needed a license to operate a scooter under 50 cc.
Well, it doesn't say that it had any cc's, so the presumption of lenity would go in her favor.
I'm not aware of that.
What type of vehicle is it alleged that she was operating?
Scooter? License plate on it, so I guess it's required to be registered.
They have bike license plates. That doesn't necessarily mean one thing or another.
So the only indication is that the scooter's under 50 cc's is her statement. All right. And at this juncture, I don't see anything that indicates anything aside from that, so I will not find probable cause. And ma'am, I will release you ROR.
Paperwork here, we're done with it.
Okay.
Shanice Ward. Good morning, ma'am.
Good morning.
How are you?
I'm good.
Ma'am, 3 counts have been presented. Grand theft auto. Let's see, motor vehicle number or plates or decal. Let's see, invalid and also misuse of a temporary tag. I do find probable cause to detain you. In reference to conditions of release. Looks like bond has already been set by I don't see the I can't read the signature.
It's Judge Dennis Bailey.
Okay, so Judge Bailey already determined that your bond should be set, ma'am, at $10,000 on count 1, $3,000 on count 2, $2,000 on count 3.
Judge, I'm going to respectfully request, I know that Judge Bailey set those bonds, but that was without hearing any of her financial circumstances in terms of her ability to afford bond or bond out. I would ask the court to reconsider. We're asking for a lower bond. I have information to that effect.
I'm looking at the allegations and some of the statements made in the allegations, and obviously Judge Bailey is more familiar with the case than I am, and I will respectfully decline to alter the bond amount set by Judge Bailey. So again, bond remains as Judge Bailey has said it, $10,000 on count 1, $3,000 on count 2, $2,000 on count 3. And let's see, Susana Hernandez Fernandez.
North Broward, Your Honor.
Good morning, ma'am. Can you hear me?
No speak English.
Okay, we do need an interpreter. We'll come back to you, ma'am.
I called, they said they'd be here at 9.
9? Okay. Thank you. And Renee Barlow.
Sí, pero no puedes hacer la llamada. Who's next, Your Honor? I'm sorry.
Barlow. Barlow. Good morning, ma'am. One count of aggravated battery has been presented. I do find probable cause to detain you. As some conditions of release to the parties wish to be heard.
Your Honor, state would be requesting a $10,000 bond in order of no victim contact, no possession of firearms or weapons, based on the level of violence alleged in this matter.
Defense?
I'm sorry, Judge, I didn't hear what the state said.
The state requested, I believe, $10,000. Is that correct?
Yes, sir.
No firearms or weapons.
Okay. Judge, she's been in South Florida for 10 years and currently is unemployed. She's a student at Florida Gulf Coast University where she attends online and also goes to classes locally. At this point, she has no money in the bank. I don't believe there's a significant history. We were going to ask the court for a $1,000 bond.
Stated of the priors.
Possession of cannabis from last year, Judge.
All right. I will set bond at $7,000. I will order a no contact with the victim, no contact with the co-defendant. No firearms, no weapons, and no return to the premises. Good luck, man. Shatara Higgins.
Bonded out, Your Honor.
And for the record, I do find probable cause. Dorothy Adams.
At North Broward, Your Honor.
No, thank you.
North Broward, Your Honor. Approaching.
Thank you very much.
Next, please, the judge.
Hello.
Good morning, ma'am.
It's asking $1,000 be left in place.
Okay,
Yes.
ma'am, one count of grand theft has been presented. I do find probable cause to detain you.
Okay.
And I did hear the defense argument, state.
No, nothing to add, Judge.
Okay. Ma'am, I will set bond at $1,000.
Your Honor, I would ask that just there be an order of no return to this specific target on Hollywood Boulevard in Hollywood.
That's
Okay.
fine.
All right, ma'am, then while this case is pending, no return to that target at 3251 Hollywood Boulevard, Hollywood, Florida, 33021.
Okay.
All right?
Okay. And the bond is posted for 1,000. I can contact the bail bondsman and get that taken care of.
Yes, ma'am.
Okay.
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 All right.
Anything else I need to know or should do?
Well, I can't tell you what to do, but in reference to how you're proceeding this morning, the bond has been set at $1,000. I'm ordering you not to return to that premises, okay?
Okay.
And make sure your address is up to date at the clerk of courts, and you need to check the clerk of courts website for an upcoming court date in the next 30 days.
I need to check the court's website. Okay.
Clerk of courts website for Broward County.
Okay.
If your address, and that's important, if your address isn't current in the court file, notice will be mailed to that address. So you want to make sure that your address is current in the court file. That's for everyone.
Might be a bit high.
Okay?
Okay.
Let me see.
Okay.
Take care, ma'am.
I know.
Thank you.
You're welcome. Ashley Ricardo.
Bonded.
Bonded? Okay. And Jacqueline Callie.
Just give me 1 second. Don't ask for no contact, it's police officer. That's fine, yeah.
Jacqueline Callie.
That's not necessarily.
North Broward?
We have a Jacqueline Nicole Callie, Calley. In North Broward.
Is there anyone in North Broward?
Jacqueline Nicole Callie.
Kelly, Judge wants you right now. Over here. Approaching, Your Honor.
Thank you. Ma'am, good morning.
Good morning.
Ma'am, 4 counts have been presented. That's grand theft auto, possession of cocaine, possession of MDMA, and driving with a license suspended, third or subsequent offense. And ma'am, I do find probable cause to detain you.
Judge, she's asking for pretrial release. She's lived here 30 years. She's self-employed, working with her father, and is going to reside with her father in Pompano at a floor cleaning business. And also to note, her husband has just passed away, leaving her financially enabled to post a monetary bond. The funeral is actually tomorrow for her husband, and so she's asking to be released. Standard pretrial.
Ma'am, first, I am sorry for your loss, ma'am.
Thank you.
As well, I certainly sympathize with her loss, but I would note, and I would be objecting to release the pretrial. She has a pending felony in Brevard County for uttering a forged instrument and grand theft. She has a warrant out of Delaware from September 18th of this year for theft over $1,500. She also has a prior theft and fraudulent use of credit card, 2013, out of Brevard County.
Oh, God, please.
Okay, and do you have anything which you qualify for pretrial?
Please, Your Honor.
Ma'am, one of the concerns I have is that it says that your permanent address is not in Broward County. That you've been residing at that address for 480 months. Do you live in Broward County, ma'am?
I live in Broward County with my father. Yes, Your
Okay.
Honor.
All right.
I was just on my way to my husband's funeral. We were separated, and his mother just told me that he had passed away, and she made funeral arrangements, and I was on my way to his funeral.
Need anything else, okay, ma'am? You don't need
Ma'am,
to tell me.
I will find probable cause to detain you. However, I will place you on pretrial with the GPS monitor, and I will order that you be allowed to attend any funeral services.
Judge, is that open schedule?
At this juncture, no, but I am allowing her to go to any funeral services or any services related to the death of her husband.
Thank you, Your Honor.
Just we need, so we can have for pretrial the address and the contact information for your father, so they can verify and get you out today?
Do you want to have her call you, or do you want to put
No,
that?
she can tell us.
Okay.
She can.
It's,
I just
The
need enough
address-
to put it on the record.
address is 111
No,
Briney
Pompano.
Avenue,
Okay.
Pompano Beach, Florida.
Okay, so you need me to write it down. Okay, I'm sorry, ma'am, what is it?
111 Briney Avenue, Pompano Beach, Florida.
111 Ronnie?
Briney, B as in boy, R-I, N as in Nancy, Y,
Boulevard?
Avenue,
Avenue?
apartment 702.
Okay. And that's
Okay,
Pompano, and then what's the contact for your father?
His phone number is 954-647-5852.
What's his name?
James Sutherland.
James Sutherland, okay.
Yes.
It's only like surrounding states. The reason I brought it up is because
What's the name of your husband for the funeral arrangements, ma'am?
Lance Callie.
And do you know where that's gonna be at?
Yes, it's in Brevard County. You can call his, you can notify his mother. His mother is Dorothy Callie.
You're not allowed to leave the Tri-County area, so that's the problem. What about if it's open schedule?
That's the problem. Would you be able to post a monetary bond, ma'am?
If I got out, I could post it, but not from in here, I can't.
Is there anyone who, would your father be able to assist?
I've tried contacting him, and he's not aware of, he doesn't know anything about the law system and posting bond. He just doesn't know what to do.
All right, I'll delete the GPS. Yes, ma'am. Solely for the purpose of attending the funeral arrangements.
Thank you so much, Brenner.
Good luck, ma'am. And again, I'm sorry for your loss.
Thank you.
Ma'am, you're gonna have to report to pretrial. You're gonna have to report to them as soon as you get it out.
Okay.
To report to pretrial? So, oh, report, but she'll be released. Okay. Sure. So you're gonna need to report to pretrial services on Monday and get your schedule and your pretrial officer, because you're gonna have to call in and report in person.
So make sure you're back
Okay.
here.
There's a map, if you can ask for the map from North Broward deputy. So you're gonna need to be there by noon to noon to 3. They're gonna close early probably on Monday.
Okay.
No? No.
Okay.
Monday's normal.
Normal Monday operations, okay.
Normal operations on Monday.
They close at 3:30, I think, right? No time, just get there early. Get there by noon.
Okay.
Okay.
Thank
Right.
you.
Good luck, ma'am.
Thank you.
You're very welcome. Sonia Masri.
North Guard.
She has no bond holds on the other counts or no?
5 and 6.
Your Honor, may I approach? I have some paperwork.
Shown to opposing counsel.
So information's been filed.
It's the original PC information.
Yes.
So what that is?
All right, and state you've added which counts?
The armed burglary was added, Your Honor. Your Honor, I can advise the court, I spoke to Jennifer Gilday about this case. She is the assigned ASA. In full candor, she is represented by Robert Trackman. She was arraigned yesterday on all these charges, and what I was advised as an officer of the court, Mr. Trackman conceded, he was supposed to have, there was supposed to be an Arthur hearing scheduled yesterday. It got reset for December. He conceded proof evident or presumption great and wanted to proceed as far as the issue of setting bond. We're here today, as the court is aware, on the change of charge and add charges.
And
that would be,
So that would only be counts 2, thank you. The firearm by felon, let's see.
it would,
That as count 3 on your information, it's count 2 on the,
yes, that was a change of charge.
okay.
Just have one moment. On that count, bond was originally set at 5,000.
Spoke with her. She's been a resident for 35 years, and she says she can afford between $500 and $750 to a bondsman.
The,
And was count 4 presented previously?
the fleeing and eluding?
The aggravated fleeing and eluding?
Yes, it looks like that was upfiled to aggravated fleeing and eluding. That originally was set at $2,500. I'm gonna ask, even though it was upfiled, I'm not requesting that that be modified from the original $2,500.
And what about 5 and 6?
The armed burglary and resisting without violence were,
Not 5 and 6 in the information, 5 and 6 on the
yeah, I don't have,
packet. It's case number 18-13389 CF10A.
yeah, those specifically, those charges are the armed burglary charge and the resisting without violence.
Okay, and yesterday that was set at no bond on.
I don't know that the bonds were specifically addressed by Judge Bailey. I would be requesting, considering she's already being held no bond on the robbery firearm, I did present the court with a copy of the original probable cause affidavit. And that, based on the representation that Mr. Trackman did not have any argument against proof evident or presumption great on any of the counts, and that she was before Judge Bailey on all counts yesterday. I'd ask the court, just for purposes of this hearing only, to make a finding of proof evident or presumption great on the armed burglary and hold her no bond on that count.
All right, I'm going to go to her on recall. I need to get a hold of Mr. Trackman.
I've called his office. I haven't been getting through to anyone. I'll try again, though.
Okay, ma'am, I'm going to recall your case and contact your attorney.
Okay.
Good morning, and let's see.
There's one in Maine and there's one at the satellite jail.
We have Azucena Hernandez. Can you please place the interpreter under oath?
Hernandez. Come on. No problem, John.
I do. Esteban Rojas, ROJAS.
Good morning, ma'am.
Buenos días, señora.
Buenos días.
Good morning.
Ma'am, do you speak English?
¿Usted habla inglés?
Spanish?
¿O español? No
Solo
English.
español.
Only Spanish.
Are you able to understand what the interpreter is saying at this juncture?
¿Entiende en este momento al intérprete?
Sí.
Yes.
Okay,
This is Herrera Fernandez on 2.
yes.
Este es Herrera Fernández.
Sí.
Ma'am,
Yes.
2 counts have been presented. Petty theft,
Señora, usted tiene 2 cargos presentados en su contra. Hurto menor,
second degree misdemeanor,
que es una contravención de segundo grado.
and use of an anti-shoplifting device.
Y utilización de un dispositivo para facilitar el hurto en comercios.
And
Sí.
ma'am, in reference to probable cause, I do find probable cause to detain you.
Y con respecto a los indicios probables de delito, considero que sí existen indicios probables para su detención.
And in reference to conditions of release,
Y en cuanto a las condiciones de excarcelación,
Adam, are you able to post bond with a bondsman for $100 to $200?
señora, ¿usted tiene posibilidad de pagar una fianza mediante un fiancista por un monto como de $100 o $200?
Sí.
Yes.
Requesting it stay in place, Judge.
Entonces voy a solicitar que se mantenga tal cual, señor juez.
and state.
Fiscalía.
Only only other thing I'd ask is no return to this Marshall's, Your Honor.
Lo único que pediría su señoría de parte de la fiscalía sería que se le prohíba regresar a este almacén Marshalls.
Sí.
Okay, ma'am, I will set bond on count one at $25, count two at $1,000.
Bien, señora, la fianza para el primer cargo es $25, el segundo cargo es $1,000.
In order that you not return to the Marshalls at 500 North University Drive,
Y se le prohíbe regresar al Marshalls ubicado en la 500 North University
Pembroke Pines, Florida,
en Pembroke Pines, Florida.
33024.
33024, el zip.
Good luck, ma'am.
Buena suerte, señora.
Buenas, gracias.
Thank you.
You're very welcome. And we had one more.
At Maine, I believe, Judge. I'm not sure.
Can you make an inquiry?
¿Quién necesita interpretación al español allá?
No, okay, maybe I'm mistaken.
No, Your Honor.
Okay. You can ask at any facility, just in case. I hate to call you back.
Yeah, can they hear me from?
Yes.
¿En alguna de las otros centros de detención alguien necesita interpretación al español?
Okay. All right, thank you very much.
This
wait,
gentleman
is
doesn't-
this-
Yeah, just.
I'm sorry, does he need the interpreter? Does this gentleman need?
no,
this?
Judge.
Okay. All right, thank you very much. And you gentlemen were waiting on,
I'm sorry, Judge?
which cases were you waiting on?
I'm waiting
And
on
you-
Palacio Alvarado. He's in Pompano.
Last name is Alvarado?
It
Yes.
should be at the end of the docket. It was a medical reset.
That got reset from the last 2 days.
Okay, I see it here.
Yes, I'll do it with you. Judge, we're getting him.
Okay, thank you. Mr. Alvarado?
Yes, sir.
Sir, good morning.
Good morning.
Two counts have been presented, dealing in stolen property and false verification of ownership to a pawnbroker.
Judge Larry,
Sir.
Larry Schweiger, on behalf of Mr. Alvarado, I'm standing in for Danny Rosenberg, Judge. Judge, we have no probable cause argument on the case. He is in front of Judge Bailey, it looks like. At this point, the only issue we have with the court, if there's any, is if the court can sign a order allowing him to go to SAP program. We're working on getting him into a BARC facility at this point, and in the interim, if he could be in SAP, that would be much more helpful.
Okay, any objections, State?
No, Your Honor. I spoke with Mr. Rosenberg in court yesterday about this case.
Okay. Bonds have already been set by your assigned judge. Count one, $3,500. Count two, $1,000. I'll leave the bonds in place, and I will order that you go into SAP per your attorney's request, sir.
Thank you, Judge. We'll take up other issues with Judge Bailey. Thank you.
You're very welcome. Good luck, sir. And, yes, sir.
Morning, Judge. On page 5 of the docket, there's Aaron Spencer.
Aaron Jerome Spencer.
He's there in the main jail, Judge.
Mr. Spencer, sir, you have a warrant on case number 1801040MO10A. on a trespassing charge. I do find probable cause to detain you, sir. And bond has been set at $500.
Judge. It's a simple trespass, Judge, at the SunTrust.
Do you have Mr. Landere?
It's not necessary for these first appearance hearings.
You're correct, but technically, the trespassing would be a victim crime.
There's no victim in this case, Judge. He was just on the street in front of SunTrust Bank, so there's no victim listed.
The SunTrust Bank would be the victim in the case. So, we could have Mr. Landere stand in for that purpose.
I'll call Mr. Landry, Judge. If
If he can
I'll
be
call the
available
other two
by-
cases, Judge. I'll get him down here.
Okay, if he can be available by phone if he's not in the building.
Mr. Spencer, you could have a seat. I'll call you back a little bit later.
Yes, sir.
Judge, on page 9 of the docket, there's a Chauncey Ditzel. He's a medical reset. He's over in North Broward.
Do we have Chauncey Dissel?
He's a medical reset, Judge.
Or it needs to be reset today?
Yes.
Okay. All right, we'll reset it until tomorrow.
And then lastly, Judge, on page 19, I don't have a docket, so I'm not sure exactly where it is in the docket, except that it's on page 19. There's a Logan DeVore.
I'm sorry, just one moment. Signing your privilege order. Last name is DeVore?
Yes, Judge. And he has,
That's right, I'm looking for the packet.
okay. It's 19, Logan DeVore.
Okay, Logan DeVore.
He's at the main jail. And just so the court is aware, count 1 is a municipal ordinance offense. He's not going to be able to resolve that. He has,
The basis of violation of probation appears to be, sir, you've been charged with 3 counts. The municipal ordinance violation, it's like for urinating in public, also 2 violations of probation. The violations of probation, the bonds have been set at no bond, sir.
he does have a court date before Judge Usan on the 2017 VOP at 8 o'clock, and I discussed that with him already.
All right, I'll set on count 1, a bond at $25, and bonds have previously been set on counts 2 and 3 at no bond, sir. And your hearing is on 11/26 at 8:30 a.m. Good luck, sir. Which one? Oh. Here we go. Okay, and is anyone else waiting on a case? All right. Were you waiting on one? Your family member? Okay.
Good morning, y'all.
Morning, sir.
I'm the bondsman with the family, so.
Okay, and the last name is?
Watkins.
Watkins.
It's on page 14.
Towards the end.
14.
Let's see. It's after Wayne?
It's the first one.
And the last name, I'm sorry, is?
Watkins.
Watkins, I still don't see it.
Watkins.
Oh, found it, okay,
Top of the page.
all right.
All right.
And Mr. Watkins, sir. You've been, one count of child abuse has been presented, sir. I do find probable cause to detain you. And as to conditions of release, and so you're aware, sir, you do have two people present. One is your bondsman?
Yes.
And your, and ma'am, and you're your girlfriend is here, Ms. Martinez. Okay, so you do have two people here for you. And in reference to conditions of release, defense.
Judge, he's a 20-year resident of Broward County with a military history. I don't believe he has any priors at this point. I believe he lives with his girlfriend who's present in the courtroom. Doesn't have any money in the bank, so we would be relying upon her potentially to bond him out. We were going to ask the court for pretrial release or potentially a $1,000 bond. I'm not sure. He can't afford bond at this point, so we were going to see if his girlfriend would be able to bond him out.
Okay, do we know if DCF has been called, that there's a dependency case that's been initiated?
Your Honor, I don't know. I do know that the only thing I can tell you at this point is the mother of the child has obtained a temporary injunction on behalf of the minor.
And ma'am, are you the mother of the child? No. Okay.
And Judge, just to clarify, in residing with his girlfriend who's in the courtroom, that the alleged victim child does not reside at that location, so no contact would not be an issue.
The only reason I asked about the mandate, well, about the DCF investigation is because I'm looking at a whole lot of mandated reporters, including myself. So,
So I'll be contacting the arresting officer to, if they haven't been contacted, I will have the officer contact them because the officer will have information about where the child is currently present.
okay. And in reference to conditions of release, are the parties asking for any specific conditions of release? I heard pretrial from defense state.
Nahum Joseph on behalf of the state. Your Honor, based on the nature of the facts, the state will be requesting a $5,000 bond, in addition to no weapons and no contact with the victim.
Your Honor, just speaking with the girlfriend, she says she's not able to afford $500 towards the bond, so I'm just here for support as well.
I'm looking at the facts that have been alleged,
Pay 10%, which is $500.
just the allegations alone, and based on the nature of the allegations, I will set bond at $5,000 and order no contact. And do we have the initials of the minor? AW.
Your Honor, it's going to be AW.
And that's until further order of the circuit court.
Say circuit court judge, do you mean, does that include dependency court?
That would include dependency and/or family court, who would retain jurisdiction over that matter.
Thank you, Judge.
You're welcome. So, good luck, ma'am. And, sir, you do have two people here for support. They've heard everything that I've said, and they had the opportunity to discuss the matters with you. They may reach out to you, or you may reach out to them in the interim, okay? All right. Good luck, sir.
And Your Honor, Your Honor, is the court declining to order no firearms weapons at this time?
No firearms, no weapons.
Your Honor, I have one more person. I think you called the cross arrest or the co-defendant in this previous case, but it's on page 16 for Gene Gillis. Spoke to the mom for I'll bring.
Last name is Gillis? Or
Yeah, his name is Gene Gillis.
Okay.
Page 16 is the second name.
Present at the main jail.
It's gonna take me a moment because I have to sift through the packets to find the.
Okay, sorry. I mean co-defendant. I'm sorry. Yeah, Gene Gillis.
Oh, Gene Gillis. Okay.
That's who had the ag.
I'm not seeing the packet. Okay, thank you. Let's see. I'll call it in just a moment.
No problem.
Thank you. And Sonia Masri. Oh, that's the one we had on recall?
I'm trying Mr. Trackman's cell right now.
Okay. We'll call Ms. Masri in just a moment. We'll wait for her attorney. Angel, the last name Marte?
I'm sorry, Judge, are we not doing Gene Giles? Gillis?
I'm looking for the packet on that one.
Oh, you are? Okay, thank you.
So good morning.
Good morning.
Two counts have been presented. One is a trespassing, the other is an outstanding capias on carrying an open beverage container in public. And I do find probable cause to detain you, sir. And I will set bond on count one at $25, count two at $50.
Judge, for Mr. Marti, I know they're municipal ordinance cases. He would normally be entitled to an attorney from the city, but in speaking to him, he's asking about trying to resolve these.
I don't have anyone from the city here. And which city is this? 48, that's Hollywood. If Mr. Landere were to come and he could stand in for Hollywood, at least one of the cases is Hollywood.
I'm not sure even how to answer the question, ma'am, because
He indicated to me he'd like to resolve it without an attorney.
Sir,
I don't know.
I'm not asking you to talk about the facts of the case. Anything you say is being recorded and can be used against you at a later date.
I'm understanding, sir.
Okay.
I'm
Hold on. I know you have a lot you want to tell me, but
the thing is,
the reason I am not inclined to resolve it at this juncture is the prosecutor on the case isn't here. They're required to be here. They're not here, and one of the cases is in Hollywood. So that, unless they knew to be present today, we have one from Fort Lauderdale that may be coming shortly, and
Your Honor,
sometimes he stands in for that person. So I would be able to resolve it at that time. I could put you on recall if that were the case. Recall means I would call you again at, later in the docket.
Yes, sir.
Okay.
Yeah, later.
Okay.
Yes, sir.
Yeah, when we're not on the record. If you print it out, I can take it now. My judicial assistant's on vacation this week, so you can send it to Judge Diaz's J, Judge Carpenter's J, any one of my colleagues, and let them know. I'm MW, but the problem is I don't always get those emails. They typically go to her. Sorry. Yes. Court's in a brief recess. This was Mr. Watkins, that I've already addressed that one, correct?
Yeah, you were
I inquired about it, okay. So as long as they've been notified, that's all that's required. All right, thank you.
And I just got off the phone with Mr. Trackman, so whenever you want to recall Ms. Masry's case.
Okay, just one moment. I have Mr. Gene Giles, or Gillis. Sir, good morning.
Good morning.
Sir, 2 counts have been presented. Aggravated assault with a deadly weapon and battery. And I do find probable cause to detain you. And as to conditions of release,
Your
request
Honor,
to be heard.
the state is requesting a $10,000 bond for count 1. And as to count 2, states will be requesting a well, that 1,000 would be fine, Your Honor. And also conditions of release: no victim contact, no possessions of any weapons, Your Honor. And just to let Your Honor be aware that he does currently have a pending case in front of Your Honor, resisting without violence and disorderly conduct.
Okay, and defense.
Judge, he's an 11-year resident of Broward County, has family local, lives with his girlfriend, pays rent. I believe his mother as well. I think that's who the bondsman mentioned he was here on behalf of. At this point, he doesn't have any money in the bank, so we were asking that, Your Honor, to set bond on count 1 at $3,000 and leave count 2 at $1,000.
I believe I set bond on the co-defendant at $7,000. And is that correct? Okay. And
Your Honor, one other issue. I think they're neighbors, if I'm not. So I don't know if they distance or if they have somewhere else to move. So.
Judge, I believe he can stay with his mother if that becomes an issue. However, it is next door, so you still wouldn't have to have contact necessarily.
it's next door, like directly next door? Is it in a house or an apartment?
Apartments.
No. All right. Sir, I will set bond on count 1 at $7,000. Count 2 at $1,000. And I will order no contact with the victim or the co-defendant in the case. Also, no weapons. Good luck, sir.
There you go.
Happy Thanksgiving, everyone. Thank you.
Thank you. And Mr. Trackman was available on which case?
Well,
Is that,
it's Masri, Your Honor.
okay. And did you,
Well, I'll wait till
did
we
you
get
post
her.
his number?
Well, here's the thing, Your Honor, if we could go, is she at North or,
I'm sorry?
is she at North, if we can go to,
Well, do you have a number for him?
I can give you a number, he said.
I don't want to say his phone number on the record.
No, I know, I'll write it down, I'm saying,
Okay.
okay. Let me just take this down.
Okay, recalling Sonia Masri.
North Broward.
For this, any sex bad case of child abuse is handled by sex bad. Just put that on the computer. No, under the computer. Face that up.
Right?
Under there. There we go, thanks. Yeah, you separate it, yeah. Well, there'll be instructions on what to do with it.
Please leave your message for 9.
Your Honor, I can tell you, as an officer of the court, he did,
I do have to hear from
okay.
him on that. Because you're asking me to hold no bond, and she's entitled to have her attorney present.
Please leave your message for 9.
All right, I will try one more time.
Good morning, law offices.
Mr. Trackman,
Good morning, Your Honor. Thank you so much for allowing me to appear telephonically.
you're welcome. You have Sonia Masri, and we have her on recall this morning.
So I understand. Mr. Linder explained to me that there was ad charges.
Yes, I'm waiting for her to arrive back at the podium momentarily. We called her earlier, but because of the issues that have arisen. I wanted to make sure that you.
I'm right here, Your
No,
Honor.
it's right, Your Honor.
She's here. And, all right. Apparently there was a hearing yesterday.
We were in front of Judge Bailey yesterday, Your Honor,
Yes, sir.
and we're reset for the first week of December with regard to it was scheduled for an Arthur hearing, and we basically deferred yesterday and reset it for December.
In reference to conditions of bond, have they been set already?
I believe that there are standard bonds on the charges that were not, like felonies, and I presume those would remain in place. But there's no bond set on the no bond charge. That remains.
No bond on the robbery firearm? And
Correct.
let's see.
And I think you're adding a burglary.
There was a burglary firearm. It's been added as well. That I don't see that on the sheet.
It just says 5.
Count 5.
Yeah.
Okay, and you're asking for no bond on that one as well, State. Is that correct?
Yes, sir.
And on the firearm by convicted felon that was previously set at $5,000.
Yes, sir.
And you were asking for an increase on, let's see, count 4.
No, I was asking all the bonds, those bonds to be kept in place. The 5,000 on the
It's an aggravated fleeing and eluding.
Yes, Your Honor. But in light of the fact that she has no bond holds, I'm okay with the court keeping that bond at 2,500.
Is it 2,500?
Yes.
Okay, and Mr. Trackman, what is your position, sir?
Well, obviously, for the purpose of this, Your Honor, this is first appearance. I have no objection to the court entering the status of bonds as the state's requesting for now. Again, we're readdressing. We're going to address all these things in December in front of Judge Bailey anyway. So at this point, it's not a problem.
All right. As it reads on the packet, 2, the firearm by felon, I'll set at $5,000. Count 4, the aggravated fleeing and eluding, 2,500. 5 being the robbery with a firearm.
Armed burglary, Judge.
Is that I thought 6 was the armed burglary.
6 is resisting without violence. The robbery firearm was filed as presented, so it's not before the court today.
Okay. And so 5 is the armed burglary?
Yes, sir.
Okay. On the armed burglary, find proof evident, presumption grade, and set no bond. And count 6 is the resisting?
Yes, sir.
And I'll set bond at $100.
And, Your Honor, I would just ask that all previous release conditions be applied to these charges.
Okay, and so ordered. Ma'am, your attorney is present telephonically, and you do have a hearing in early December. So please stay in touch with him in the interim, okay?
Okay,
All right, good luck, ma'am.
thank you.
Thank you, Mr. Trackman.
Your Honor, again, thank you for accommodating me, and have a wonderful Thanksgiving.
You as well.
Thank you.
Take care. Okay, and take care, Mr. Patrick. Good seeing you. Kevin McFadden. Kevin McFadden. All right, sir, you have one count that's been presented. It's a warrant that's been issued for your arrest on a petty theft. And I do find probable cause to detain you. The bond has been set at $1,000, sir.
Judge, I'm sorry, what page?
Kevin Lee McFadden, page 5.
Oh, okay, gotcha, thank you. Judge, in this case, could Your Honor, consider ROR? It's a petty theft, nonviolent misdemeanor.
And without looking into the file, apparently he missed his original court date. Does he have any other failures to appear?
Checking that right now, Judge. Your Honor, I'm showing September this year, he was arrested on multiple cases on 3 MO charges.
Right. I'm going to decline to hear anything further because anything further may result in an increase in the bond or release conditions. So at this juncture, I'll leave the standard bond at $1,000 or the convenience bond. Good luck, sir. And we have Kester Francois.
I have a probable cause argument for the DUI. Needs 3 signs of impairment to be able to conduct a DUI investigation. They did say a strong odor of alcoholic beverage emanating from his breath. His eyes were glassy. The third being that his clothes were disheveled. I'm arguing that clothes being disheveled is not enough to be able to serve as one of the 3 factors.
The driving pattern would be, though, correct?
I'm sorry?
The driving pattern?
Also noting that he had to use the door to assist in keeping balance, swaying from side to side as he walked to the rear of his vehicle.
That was after the DUI investigation was underway, and he needs 3 factors to pull him from the vehicle.
The driving pattern, you didn't respond to that.
The driving pattern could be, I guess it could be seen either way.
I noted the driving pattern and the fact that it was through an active school zone, the numerous attempts to get his attention. So I did read the probable cause affidavit, and I will find probable cause to detain you, sir. Let's see, 6 counts have been presented.
Yes, Judge.
Okay, and that's possession of cannabis, DUI, and enhanced driving under the influence, speeding in a school zone, failure to wear a safety belt, failure to drive in a single lane. Any arguments as to conditions of release? State defense.
Judge, he's a 23-year resident of Broward County. He does have 1 9-year-old child to support, is employed in an air conditioning company, has a place to live and has to pay rent. I don't believe there are significant priors. I was going to ask the court to consider ROR.
Your Honor, based on the breath reading, I'd have no objection to pretrial, but I would ask an order of no alcohol or intoxicants and random testing.
All right. Sir, I'm going to release you to pretrial release. No alcohol, no intoxicants while on release, and further, I'm going to order that you wear a TAD monitor, sir.
Ask that you waive the cost of the TAD monitor, seeing that
if he fills out an application and he qualifies for your services, then it would be waived. So, sir, did you hear that? If you fill out an application for the services of the Office of the Public Defender and you're declared to be indigent, the cost would be waived.
Okay. He filled out an application this morning here, Judge.
That will be determined at a later time, I guess.
still want him to have arrears while the clerk application is pending.
And the sooner that application is processed, the better. Unfortunately, I've seen some applications that have been delayed in filing for quite some time. Delayed, I mean, they just haven't been submitted to the office of the clerk, so the sooner that gets to the clerk's office, the better. Yes. And Wayne Lee Golden.
Yes, sir.
Good morning, sir.
Good morning.
Sir, 2 counts have been presented, petty theft and trespassing. I do find probable cause to detain you, sir. And that's the conditions of release. State defense, any arguments as to conditions of release?
Judge, at this point in speaking to Mr. Golden, he would be unable to afford that $100 bond. He's a 3-year resident of Broward County, does not have any money in the bank, and basically works doing day work, day-to-day basis. Being that this is a non-violent offense, I'm asking Your Honor to release him ROR.
Just pled out a theft, Your Honor, 2 weeks ago, and he was arrested on that theft on a capious failure to appear. He's also pled out, 1, 2, 3, 4. In addition to that, 4 other cases this year.
I will respectfully decline the request to release him ROR at this juncture. I'll set bond on count 1 at $100, count 2 at $25.
Would he be able to resolve this today, Your Honor?
State, do you have an offer?
Your Honor, the offer on the theft would be 10 days, considering he just pled out a theft 2 weeks ago.
And how many theft-related offenses does he have in the past?
I'd have to check, Your Honor. While I'm checking that, though, as far as Broward, he also had a trespass late September this year, exposure, sexual organs, disorderly intoxication in August, trespass in June, failure to leave property in June, and another trespass last year. One moment.
The reason I asked about the previous thefts is any subsequent theft, if he's adjudicated on this, would it subject him to enhancement?
Yes, Judge.
Just checking if he's had thefts elsewhere, Your Honor. Yeah, I see a previous grand theft out of Virginia.
Was he adjudicated?
He was.
Okay. And then that would
Another
subject him.
Another grand theft adjudication out of Virginia.
All right, and the offer is adjudication 10 days?
Yes, sir.
And were the items recovered?
It appears so, yes.
All right. So just adjudication 10 days, Broward County Jail, and court costs as well, correct?
Sir.
And as to the trespass?
It'd be a time served.
Is that what he'd like to do?
Yes, Judge.
Okay, can you please place Mr. Golden under oath?
Raise your right hand. I can't.
Sir, do you swear or affirm that everything you're going to tell me is the truth and nothing but the truth?
Yes, sir.
Okay. Can you state your name for the record?
Yes, sir.
Can you tell us your name for the record, sir?
What did you say?
Say your name.
What's your name, sir?
What is your name?
name?
What is your name? State your name.
Wayne Golden.
Okay. Sir, are you currently under the influence of any you can put your hand down, sir. Are you under the influence of any medication, drugs, or alcohol that would affect the way you think?
No, sir.
In the past year, have you been treated for a mental illness, sir?
Yes, sir.
Okay. How long ago was that?
What did he say?
Have you ever been treated for mental illness?
Oh, no, sir, no, sir.
Okay. And you understand you've been charged, well, 2 counts, petty theft. Maximum penalty is 364 days in the Broward County Jail, or 12 months probation. Trespassing, maximum penalty 60 days in the Broward County Jail. And also, because of your history, any subsequent theft would result in enhancement. So you could be charged as a felon for the next one. You understand that?
Yes, sir.
I'm not suggesting that another one would occur, but if it did, you'd be giving the state the power to charge you as a felon. You understand that?
Yes, sir.
Okay, and you wish to go forward?
Sir?
You wish to go forward?
Listen.
You wish to go ahead and resolve with the...
Yes, sir.
You understand if I take your plea, you'll be waiving certain constitutional rights.
Yes, sir.
So those rights include your right to maintain your plea of not guilty and have a trial, your right to present defenses, file motions and pleadings, your right to remain silent, have the state prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. You understand those rights, sir?
Yes, sir.
You wish to waive those rights so you can take this plea?
Yes, sir.
Are you satisfied with your attorney?
Yes, sir.
Have you had enough time to talk to her?
Yes, sir.
You understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings?
Yes, sir.
Under the Jimmy Rice Act, if this was sexually violent or sexually motivated, or if you previously been convicted of such an offense, taking this plea would subject you to involuntary civil commitment.
Okay.
And knowing and understanding everything we've discussed, sir, how do you wish to plead? No contest? Or
Yes, sir.
Okay. Is there a factual basis state?
Yes, Your Honor, relying upon the probable cause affidavit.
All right. Is there a stipulation? Is there a stipulation as to the factual basis? Okay. Based on the stipulation of the parties, the court's review the court documents, including the probable cause affidavit, I will find sufficient basis to take your plea. Sir, is there anything you'd like to say before I pronounce sentence?
Anything else you'd like to say?
No, sir.
Sir, I will accept your no contest plea, find that you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you're satisfied. Do you understand the nature of the charges against you and the consequences of taking the plea? And I will honor the agreement you've reached on count 1, the petty theft. I will adjudicate you, sir. This court costs, as well as I'll sentence you to 10 days in the Broward County Jail with credit for, how many days does he have in so far? Okay. And so it appears that
When I get arrested yesterday.
Okay. And on count 2, an adjudication, court costs, and credit for time served as well. It's on the trespassing, sir. You have 30 days to appeal the court sentence. Good luck, sir. And I'll give you 6 months to pay the court costs. Lionel Suazo. Sir, good morning.
Good morning.
Sir, you have 3 separate cases. Case number 170-16912, TC28, case number 160-56769, TC28, and 17000-215-MM20A. Each one has a no bond hold. And they do find probable cause to detain you, sir. The warrant was issued by, looks like Judge Zeller, sir. You have a hearing before your assigned judge on November 26th at 9 a.m., sir.
Okay. Thank you.
You're welcome. Good luck. Torrance Smith.
Medical reset.
Fred Burke. Mr. Burke, sir, good morning.
How you going, Judge?
Doing well, sir. How are you?
Great.
Sir, one count of loitering and prowling has been presented, and I do find probable cause to detain you. And in reference to conditions of release, any arguments?
Judge, we are going to ask for ROR. This $25 bond, Mr. Burke is not going to be able to afford at this point. He's indicated, we're asking the court to release him ROR.
State?
Your Honor, my concern, one, that this involved the circumstances in this case. The court's familiar with the probable cause affidavit. If I could have one moment.
Loitering and prowling, so.
I am. And I read the probable cause affidavit, and I did find probable cause.
Your Honor, I think this case might be appropriate for Judge Lerner, and I can tell you between 2009 and 2016, he had numerous cases dismissed for competency grounds. 2016 trespass was assigned to Judge Lerner.
Any objection to transferring the case to mental health court? All right. And based on the fact that the representation in several cases have been dismissed for competency or lack thereof, I will ROR Mr. Burke and transfer to mental health court. Good luck, sir. You able to get a hold of Mr.?
He's right here.
Oh, there he is. Good morning. And is this on Spencer?
Yes, Judge, this is on Mr. Spencer, Aaron Spencer.
Okay.
Don Laundrie, City of Fort Lauderdale.
Do we have Aaron Spencer? Mr. Spencer, good morning.
Good morning.
Okay, and this is in reference to
This is a trespass charge.
And is there an offer?
Yes, Judge, it's gonna be a withhold court cost and no return to,
The bank. SunTrust.
man, yeah, it looks like 601 West Broward Boulevard. My copy's a bit smeared.
Do you have a copy?
It's the same copy, Judge.
Yeah, it's just a bad copy, it looks like. But Judge, it was from the SunTrust building, and it's the zip code was 33311. We're just asking you not return there for a year.
And so withhold court cost, no return to SunTrust at 601 West Broward Boulevard, Fort Lauderdale, Florida, 33311.
That's correct, Your Honor.
Okay. And is that what you want to do, sir?
Yes, sir.
Okay. Mr. McLaurin, you've spoken to him about?
Yes, Judge, I did.
And can you please place Mr. Spencer under oath? Oh, I'm sorry. Sir, please raise your right hand. You swear or affirm that everything you're about to tell me is the truth and nothing but the truth?
Yes, sir.
And your name for the record is?
Aaron Spencer.
Okay, you can put your hand down, sir. And you understand you've been charged with one count of trespassing?
Yes, sir.
Okay, maximum penalty, Mr. Laundrie, is that 60 days?
Yes, Your Honor.
Okay, 60 days in the Broward County Jail or 6 months probation, sir. And the offer is a withhold of adjudication. Let's see. No return to that SunTrust at 601 West Briar Boulevard, Fort Lauderdale, Florida, 33311 for 1 year, as well as court costs. You understand that?
Yes, sir.
Did anyone promise anything different?
Sir.
Did anyone promise anything different to you, sir?
No, sir.
Are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
No, sir.
In the past year, have you been treated for mental illness?
No, sir.
Okay. You understand if I take your plea, you're going to be waiving certain constitutional rights.
Yes, sir.
So those rights include your right to maintain your plea of not guilty and have a trial, your right to present defenses, file motions and pleadings, your right to remain silent, have the state prove your or the city prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. You understand those rights, sir?
Yes, sir.
And do you wish to waive those rights so that you can take this plea?
Yes, sir.
Are you satisfied with your attorney?
Yes, sir.
Have you had enough time to speak with your attorney?
Yes, sir.
You understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings.
Yes, sir.
Under the Jimmy Rice Act, if this were sexually violent or sexually motivated, or if you previously have been convicted of such an offense, taking this plea would subject you to an involuntary civil commitment. You understand that?
Yes, sir.
And knowing understanding everything we discussed, how do you wish to plea? No contest?
No contest.
Okay. And is there a factual basis? Still under A. Is there a factual basis, sir?
Your Honor, again, going back to the address that listed before, the 601 North Broward Boulevard in the city of Fort Lauderdale. Looks like defendant was there on, Judge, I can't read the date, but I'm. Judge, September 6, 2018. He was there and asked to leave several times and did not leave.
Is there a stipulation as to a factual basis?
Yes, Judge.
Based on the stipulation of parties, recitation of the facts, courts review the court documents, including the probable cause affidavit. I will find sufficient basis to take your plea. Sir, is there anything that you would like to say before I pronounce sentence in your case?
No, thank you.
You're welcome, sir. I will accept your no contest plea, and I'll find you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you're satisfied. You understand the nature of the charges against you and the consequences of taking the plea. And I will withhold adjudication, assess court costs, and order you not return to the SunTrust at 601 West Bar Boulevard, Fort Lauderdale, Florida, 33311. That's for the duration of 1 year, and I'll give you 6 months to pay the court costs in the case, and 30 days to appeal the court sentence. Good luck, sir.
Thank you.
You're very welcome, sir. You're welcome, and take care.
The major issue in this case is the traffic. So concede to possession and
Okay,
count
and Demetrice Fulmore?
How you doing?
Good morning. It appears that you have 2 warrants for your arrest on case numbers 1500105 MM20A, as well as 180000502 MM20A. And the bonds have been set at $2,000 and $2,500 respectively. And I do find probable cause to detain you, sir.
Say it again, I'm sorry.
I do find probable cause to detain you. The bonds have previously been set in your cases.
Oh, yeah, yes, sir.
All right. You have a hearing on 11/26 at 9 a.m., sir.
All right.
Good luck. We have Michael Lawson.
Medical research.
Thank you.
Jesse Taylor. We have Jesse Taylor. Mr. Taylor, sir.
Yes, sir.
Sir, one count of trespassing has been presented, and I do find probable cause to detain you, sir. Maximum penalty is 364 days in the Broward County Jail. Any argument as to conditions of release?
Judge, he has explained to me, I'm sorry I hadn't had a moment to speak to him earlier, but he is financially unable to post $25 bond. Being that this is a nonviolent misdemeanor, I'd ask the court to release him ROR.
Have you had the opportunity to read the allegations in the probable cause affidavit?
No, Judge.
I would not be inclined to release him ROR. I do have some concerns that are raised. If I release him to pretrial, I would ask for certain conditions. I don't know how you wish to proceed. All right, we're still on the record, correct? So that keeps you on. I was blinking a second ago. I just wanted to make sure.
Judge, is there mentioning standard pretrial?
It'd be with conditions if I did release him to pretrial. You're not. You don't have a copy of the probable cause affidavit, so I don't know if you see the concerns that I had based on the allegations. But if you wish to have him released on pretrial, I can do that.
Judge, is it possible for him to resolve this today? Otherwise, pretrial would be something he'd be interested in because he can't financially afford the bond.
Your Honor, just to bring to the court's attention, I'm showing he was arrested and convicted of an assault last month in Delray Beach. Trespass disorderly intoxication in September in Delray Beach. Trespass in August in Delray Beach. Picked up in Broward in August on a failure to appear. Arrested in August in Delray and a trespass and also a failure to appear. Another trespass in July. It goes on from there. I'm also showing in the state of Florida a total of 15 prior failures to appear.
All right. I will respectfully decline the offer. I'll set bond at $25 and ask that it be set before as assigned judge as soon as possible.
And, Your Honor, I would just ask, in addition to release condition in this case, be no return to this Walgreens.
No return to the Walgreens located at 10401 East Hillsborough Boulevard, Deerfield Beach, Florida, 33441. Good luck, sir. Wilson Acosta.
All right, get ready. We're coming up to yours.
Nope. Sir, I do find probable cause to detain you, but your bond has been posted. Good luck, sir. You have a hearing before your assigned judge on 11/26 at 9 a.m. November 26th at 9 a.m., sir. Anthony Rawls. Mr. Rawls, good morning, sir.
Good morning.
So you have a case on case number 180138. Let's see, 59. That's 3839 CFSNA. And I do find probable cause to detain you. The bond has been set at $1,000, sir. You have a hearing before your assigned judge on 11/26 at 8:30 a.m.
Judge, we're requesting the court to consider reducing that to $500.
Your Honor, he has a total bond of over $80,000 in his other counts. With charges like strong arm robbery, aggravated battery, burglary, I just ask that the bond be kept in place.
I will decline the request to reduce the bond, and then it's without prejudice. It can be addressed before his assigned judge at his hearing on 11/26 at 8:30 a.m. Christopher White.
See, now this guy has an out-of-state hold. It really doesn't. The way out-of-state holds work, he doesn't go to the other state until local judge.
Sir, good morning.
Good morning, how you doing?
Doing well, sir. And yourself?
I'm all right, Your Honor, I'm all right.
Sir, there's one count remaining. Looks like one count of possession of cocaine. I do find probable cause to detain you, sir. And let's see. Are there any arguments as to conditions of release?
Your Honor, he has a no bond hold out of another state for second-degree murder. I'm just asking that this bond be kept in place.
Okay. And what are the other charges on this case?
Removing serial number from a firearm, he's got a $2,500 bond. Misdemeanor possession of cannabis, he has a $1 bond, and DWLS third or subsequent $750 bond.
All right. Defense, any argument as to conditions of release?
Not at this time, Judge.
We'll set bond on count 5, the possession of cocaine at $1,000, sir.
All right, yes, Your Honor.
Good luck, sir. Elias Ramos.
Morning, sir.
Mr. Ramos, good morning, sir. How are you?
Good, how are you?
Doing well. So you have a warrant for your arrest from Judge Siegel. And I do find probable cause to detain you. It's on case number 180138888 CF10A. It's a grand theft. Bond has been set at $1,000, sir.
Well,
You have a hearing on November 26th at 8:30 a.m. before Judge Siegel.
Thank you.
You're welcome. We have Bruce Leon Coleman. Mr. Coleman, sir, good morning.
Good morning.
And this appears to be a violation of your pretrial, and I do find probable cause to detain you, sir. I see the order signed by Judge Garcia Wood. The bond has been set at $10,000 on count 1, $10,000 on count 2, and let's see. And on case number 18004747 CF10A, she has set bond at no bond, sir. You have a hearing before your assigned judge on November 26th at 8:30 a.m., sir.
Okay.
Mano Edwards. Mr. Edwards.
how you doing, sir?
Doing well, sir. How are you?
I'm fine.
Sir, 4 counts have been presented. One count is a battery on a law enforcement officer, resisting an officer without violence, resisting an officer with violence, and a municipal ordinance violation for possession of cannabis. I do find probable cause to detain you, sir. Yes, 2 conditions of release.
Judge, he's a 29-year resident of Broward County. He's gainfully employed building air conditioning units on a sort of assembly line. He lives with his father, pays rent. He does have family local. Does not have any money in the bank. Judge, I was going to ask her to set count 1 at $1,000, leave count 2, and $1,000 count 3. And if we could ROR count 4.
State.
Your Honor, as for, based on the facts, for state's requesting for count one, bond be set at 5,000, leave count two. Count three, bond be set for 2,500. In addition, request that no, weapons, no firearms or weapons, Your Honor.
Okay, I will.
Okay.
Yes.
No, nothing further, Your Honor.
Okay. I will set bond on count one at $2,000. Count two at $100. Count three at $2,000. And I will ROR count four. And in addition, no weapons. While you're out as a condition of release, sir. No firearms, no weapons.
Yeah, 75.
Good luck, sir. Norval Howard. Mr. Howard, good morning, sir.
Good morning.
Sir, 4 counts have been presented. Possession of cannabis. And you have 3 different warrants. One is on, let's see, case number 18007052. That's possession of cannabis. The bond has been set at $500 on that. A violation of probation on case number 180004888, CF10A. 2 separate counts. And they've been set at no bond, sir. I do find probable cause to detain you. And I will set bond on count 1 at $100. Count 2 has already been set at $500. 3 and 4 have already been set at no bond, sir. You have a hearing before your assigned judge. Your judges, plural. One on November 26th at 8:30 a.m. The other on November 27th at 9 a.m. Good luck, sir. James Robert Gore.
Judge, they just brought him into the room. If I may have just a moment to speak with my client
Okay.
briefly. Make it quick. Thank you.
Mr. Gore's on brief recall. Cedric Thompson.
Oh, no, I just have to talk to him. They just brought him in. I don't know.
Please do not remove Mr. Gore. Now, Mr. Thompson, good morning, sir.
Good morning, sir.
2 counts have been presented, burglary of a conveyance and petty theft. I do find probable cause to detain you on both charges. Any arguments as to conditions of release?
So she's a lifelong resident of South Florida? I'm sorry, were you asking the state to make their
Either
request?
party.
Okay. Currently working in the labor pool, living with a friend, but he does pay rent. He does have significant ties to the community, and that his mother, sister, brother, extended family all reside in Broward County. He has 2 children. One is 7-year-old that he does provide support for. Currently does not have any money in the bank. I was asking Your Honor to consider pretrial release and that he does have a valid address.
State?
Your Honor, for count, we're requesting a bond of $5,000, no return to the victim address, no contact with the victim. And in addition,
I'm not
shows
mistaken,
that.
this was a vehicle.
Yes, Your Honor, it was a vehicle, but it was.
Okay, so you were asking for $5,000, no return?
Yeah, it looks like the truck was at the person's home address, so requesting no return and no victim contact as well, Your Honor. In addition, it shows that the defendant has a lengthy history shows that he has a 2016 possession of PDP, 2014 possession of cannabis, 2010 driving while license suspended, 2008 delivery of cocaine and possession of cannabis, Your Honor. And he was sentenced to 18 months as a habitual offender, Your Honor.
Okay.
And he's had multiple other charges as well. And in addition, shows that he has a warrant out of Georgia, Your Honor, for violation of probation.
It does not appear that he's a good candidate for pretrial. But I'm looking at the
sorry, go ahead.
allegations set out in the probable cause affidavit, and I will order the no return, no contact. However, I will set bond on count 1 at $1,000, count 2 at $25. Good luck, sir.
Yeah, bless.
You as well. Alexander Navarro. Alexander Navarro?
Yes, sir. Yes, sir.
Good morning, Mr. Navarro. Sir, 3 counts have been presented. Petty theft, maximum penalty 60 days in the Broward County Jail, 6 months probation. Resisting without violence, maximum penalty 364 days in the Broward County Jail. Also, commission of resisting immersion, it looks like. Maximum penalty 364 days in the Broward County Jail, 12 months probation. There was a probable cause argument.
Judges, to the resisting with violence, my argument is that this should only be without violence. Although it says that he became combative and aggressive in attempting to push, pull, and tense away, it doesn't say that there was any violence or any attempt at violence. And it goes on multiple times to say tense, push, and pull, continue to brace himself, making it hard to handcuff, tense and pushing away from officer, forcing officer to move towards the wall. It never is violence or the threat of violence there, so I'm asking that no PC as to violence and it to be only PC without.
Your Honor, pushing away from an officer is offering violence.
Is there a case on that, or is that?
Well, a battery is an unwanted touch.
I'm not talking about battery. So.
Right. What makes it a felony is that the officer was in the course of his legal duty. This may not be the gravest resisting with, or it could be a battery and a law enforcement officer.
So it's the pushing away that you're finding it on?
I'm looking at the totality of the circumstances as stepped out in the probable cause affidavit, but I will find probable cause on counts 1 through 3 as to conditions of release, though.
Oh, it says he pulled away. It doesn't say, oh, he tense,
No, he said
push, and pull away.
Yes.
That's a stretch, Judge. With violence, I mean, to find a felony punishable with 5 years by
I
just
understand your argument.
gut feeling.
Respectfully, I have ruled. And now as to conditions of release.
Your Honor, as for count 1, I'm sorry, as for count 2, Your Honor, requesting $500 in addition to no return, Your Honor.
I'm sorry, you were asking for?
$500, Your Honor.
On
count 2.
That's the resisting?
Yes, Your Honor.
And what are you asking for on count 1?
I'm not asking for any bond, Your Honor.
And on count 3?
Not asking for any bond as well, Your Honor.
Defense?
Judge, he's a 36-year resident of South Florida. Unfortunately, his only income is a disability income that he receives, so he does not have any money in the bank. He's not working. Judge, I'm going to ask the court to consider the facts of this case and the less severity, and ask the court to release some ROR. He's advised he's financially unable to post any bond.
Our order pretrial.
Standard?
Yes.
Thank you.
To a verified address. Does he have, I'm releasing him to pretrial. Does he have a verified address? Or is this a case where I'm gonna need to have him report in person?
Judge, we're requesting that he could phone in or report in person.
All right. Our order pretrial, report in person twice per week.
Possible to do twice a month. It's incumbent, or it's hard on persons with low income to be able to make it to the pretrial office so frequently.
Well, I understand, and I did take that into account, as well as the charges that are currently,
Understood,
in this
Judge.
one felony. And that order is reviewable by the assigned judge, so.
Right.
It's in his best interest to perform well on pretrial at this juncture. That would give his assigned judge more to work with. Report in person, yes. And Brian Edwards.
Yes.
No, Broward, Your Honor.
I'm not sure what my charges are.
Sir, and that's one of the things I'm here to inform you, sir. The charge that's been presented this morning is aggravated stalking after an injunction for protection. And
Sir,
I mean, hold on, before you say anything, keep in mind that everything you do say is being recorded, and it can be used against you at a later time. I advised everyone this morning when I first took the bench. So keep in mind, this is not your trial. This is solely to determine any conditions of release if appropriate. This is not your trial. This is not an adversary hearing. So.
What's his name? What page are we on, Judge?
This is Edwards. I don't have the page number at hand.
I don't have any information or PC.
There's an affidavit to arrest.
You gave me one?
I went, can I say something? I posted publicly, I offered my apologies on Facebook. Mark Zuckerberg just had that big conference.
Sir,
I did it specifically
before you say
apologize
anything else,
for my behavior.
Mr. Edwards, Mr. Edwards.
It was never even against
Mr.
her.
Edwards.
It's embarrassing.
Mr. Edwards, you're incriminating yourself further. I would ask that you not say anything else and just talk about bond. Just talk about how much you can afford. That's all we're here for. This isn't a trial.
It was, I mean.
You're making it harder to defend the case against you by making statements on the record that are
Even
recorded.
the captain at work knows it was never directed at her. It was directed at these goddamn witches.
So you've just admitted that you did in fact send something, which could have been an element the state would have had to prove, and now you're just further talking about things.
It was against the witches.
Sir,
listen, I'm being honest with you. It was never directed at her, and I'll admit it. I really will. I've done nothing wrong. I honestly haven't.
It is my
and you know what?
intention-
I mean, I'm like, I've gone through too much. I just got another job. I've gone to all my doctor's appointments. I've done everything in my power. Everything that you've asked me to do. I'm doing everything I need to do. I know I need therapy. I'm like, I can't even believe I'm in jail. It's Thanksgiving. I really can't. I did the time intentionally because it wasn't even directed at her. I did it because I know I was wrong.
Sir.
That's why I did it.
Sir.
And now I'm in here.
Sir, I have not, this is my first time encountering you. I have not ordered you previously to do anything, but I need you to calm down for the moment. Now, you have a representative of the Office of the Public Defender who's told you to calm down and not say anything that would incriminate you. Everything you say during the course of this hearing can be used against you at a subsequent hearing. So you can order the transcript, the audio, the video of this hearing. I told you that earlier, and I'm telling you that again. So it's not in your best interest to say anything right now as to the facts of the case. We're just discussing conditions of release at this juncture. I do find probable cause to detain you, and also a warrant has been signed. So Judge Elijah Williams did find probable cause to detain you as well.
Can I go back to Fort Lauderdale Hospital?
Reference to conditions of release.
Your Honor, I'm going to be requesting a $25,000 bond, pretrial release with a GPS monitor, level 1, in order of no victim contact. Your Honor, I'm making this request not just based on the allegations, but Mr. Edwards is currently ROR'd on a pending misdemeanor stalking against the same alleged victim. The same victim that has already gone before a different judge to obtain a permanent injunction against Mr. Edwards. This will now be the third judge advising him not to have contact with this alleged victim. Your Honor, I can also advise you, and I believe the court can take this into consideration for bond purposes. I reviewed the arrest warrant affidavit from the pending case, misdemeanor stalking, and among the allegations, there were threats to kill made in that case against the alleged victim, Your Honor.
And defense.
Was the state asking for amount?
$25,000.
25,000. My client doesn't have the ability to make a monetary bond, and we all know that money doesn't make the community safe. If I can elicit, can you afford any kind of amount of monetary bond, sir?
No, I can't. I'd rather just check in the Fort Lauderdale hospital.
Do you get a disability check every month? How much is that, sir?
1,200.
1,200. Okay. Based in light of that, I'm asking that the bond be set at $10,000, so that he can be able to use his check to be able to post 1,000 to a bondsman.
I'll set bond at $20,000, pretrial release with a GPS monitor, no contact with the victim. Sir, when I indicate no contact, that's no direct, indirect, telephonic, electronic, that includes social media. Contact by any means, any third-party contact, no contact whatsoever. And
I mean, I did it to all my families again. I offer my apologies to everybody. Like, I know, like, her work is, like, one of my Facebook friends, the Biscayne Pilots. I saw it come up, and I literally did it.
Why do you think that this is helping you right now? I don't understand.
I don't.
Okay, then why say anything?
It was not even directed at anybody. It was like when we were together, it all started.
Judge,
I mean,
nothing further, Judge.
She fainted in my arms. Sure. I mean, they took it out on me, and I'm tired.
Judge, would you be inclined to get a competency evaluation?
It's,
I mean, I was supposed to go the 17th. I have it downloaded in my phone. Everything.
To be found, not to have a doctor ordered.
The order.
Well, to have a finding.
For the motion, it requires a charging document.
Well, the court can do it sua sponte. I'm not sure that the rules of criminal procedure require the court to.
If you show me otherwise, but right now, I believe it's crisis stabilization that he's requested. He's previously been in.
Can he be sent to?
If he does qualify for that, I would be inclined to do that.
To do a send to the receiving facility?
Yes.
Okay.
And then return to the custody of.
Your Honor, just for clarification, what level GPS was you ordering him to be supervised on?
The highest level, and just with the GPS, no contact.
Judge, it doesn't matter. He's going to be in custody.
At
You
this
said
juncture,
you said
but
$20,000 bond. He's not going to be able to make a monetary bond. So
I don't know if any other judge would review the matter and lower the bond. But I have placed the conditions. No weapons as well.
Okay, all right, thank you.
A psychiatric evaluation, no follow-up.
Judge, here at main jail, I'm asking if we could hold somebody up ahead of time. I have an ill inmate. I'm asking if we could call Stephen Harpal, page 16. It's coming up soon. It's just he's needing to be
The
removed.
last name
one of
is
the shelters.
Harpal. Okay, I have
Harpal.
Mr. Harpal.
I checked out this.
And Judge, I'm also requesting a photo order for injuries.
Okay, first we do have Mr. Harpal.
For a photo order for who?
Harpal, page 16.
No, but there's a photo order for somebody else or for Mr.
That's the one I need a photo order for.
I have it.
Okay.
You.
Sir, good morning.
Judge, I have a probable cause argument.
Okay. I just want to learn what the charges are before you make the probable cause argument. I will allow you to do so.
Sure.
Let's see, 3 counts have been presented, sir. One is battery on a law enforcement officer, aggravated assault on an officer, and resisting an officer with violence. There's been a probable cause argument that's raised, and yes, counsel.
The resisting with violence is what I'm challenging, although I understand that there was threats made. He was not under detention, or he wasn't resisting whenever those threats and that action was made. It was only upon them giving verbal commands for him to place his hand behind his back when he was seized. At that point, he says no multiple times when ordered to comply, but it doesn't say anything about violence once he was given those verbal commands to be to place his hands behind his back. So it's at that juncture that he was seized under the Constitution, and at that juncture, his resisting was without violence by saying no.
State.
State would counter that the officer was he was doing his legal duty at the time. The defendant obstructed by not following the officer's command at that time. He was performing illegal duty, Your Honor.
Right, and I'm challenging violence aspect, not lawful duty.
Yes, Your Honor. But the officer was performing legal duty at the time when the defendant charged at him and attempted blocking traffic and attempted to strike, and did actually strike the officer, Your Honor.
Right, but you can't resist if you haven't been ordered to comply.
Your Honor, it isn't just resisting, it's also, that's why the statute says resisting and or obstructing.
I can look up the case law, but the case law says that they have to be aware that they're under detention before this would apply.
Your Honor, for resisting, they have to be under detention. Obstructing does not require detention.
Okay. I do find probable cause to detain you, sir, on all counts as to conditions of release. Is it the next door neighbors? 500. Any arguments as to conditions of release?
Judge, he's been in Broward County for 13 years, is currently gainfully employed at a fast food restaurant. He lives with his mother, pays rent, does not have any money in the bank. I don't believe he has significant priors. Judge, at this point, we're asking the court to, hold on. Set count 1 at $1,000, count 2 ROR, count 3 ROR.
And state.
Count 1, the state is requesting bonds to be set at $1,500. Count 2, $7,500. Count 3, $1,000, Your Honor. And in addition, no firearm or weapons, Your Honor.
I will set bond on count 1 at $1,500. Count 2 at $2,500. Count 3 at $500. And no contact with no firearms, no weapons. Good luck, sir. Mr. Leroy Williams.
Judge, if we could also go back to page 11, we have Mr. Gore present.
Okay, back on Mr. Gore. Good morning.
Good morning.
Let's see, 2 counts have been presented. Robbery by sudden snatching. Maximum penalty is, 5 years in Broward County, 5 years in Florida State Prison, or 5 years probation, and resisting without violence, maximum penalty, 364 days in Broward County Jail. that's what's been presented. I do find probable cause to detain you. And as to conditions of release,
What is the state requesting?
As to count one, the state is requesting $7,500 bond set, and as for count two, no bond, but just for the record, there is allegation of violence and/or threats being made. The state will be requesting no firearms or weapons, and in addition, no victim contact.
And Judge, at this time, we're financially unable to post any amount of monetary bond. My client does not have any money in the bank accounts, property of any kind. Would be financially unable to post any amount of monetary bond.
all right, I will set bond on count one at $3,500. Count two at $100. No firearms. No weapons, and no contact with the victim. That's no direct, indirect, telephonic, electronic contact by any means. No third-party contact either. Good luck. And Mr. Leroy Williams.
Judge, I have a probable cause argument.
Sir, 6 counts have been presented. Trafficking cocaine, 28 grams, more than 28 grams, less than 200 grams. Possession with intent to sell or deliver heroin. Possession of cannabis. Possession of drug paraphernalia and restriction, a window restriction, as well as improper stop, stand, or park. And the argument for probable cause is?
Just because he had baggies doesn't mean that he was engaging in the sale. I presented case law, and I wasn't able to get your email address, and I don't have the ability to print it out. But there are several cases talking about the insufficiency of just having bags, multiple bags. Does not establish that it was automatically for the intent to sell or traffic. Let's see, specific sites would be, I provided to the state as well.
Is this just apply to count two?
There's trafficking as well.
Trafficking is, the statute requires simple possession.
Okay.
There doesn't have to be any additional evidence for trafficking. I would agree, Your Honor, the state would have no objection to the court finding PC for possession of heroin on count two with the $1,000 standard bond. But all that's, as the court's aware, all that's required for trafficking is possession.
Well, and the amount.
Well, yeah, of course, if it satisfies the amount.
All right. So that was solely the argument for probable cause?
Yes, Judge.
Okay. I will find probable cause to detain you, sir. However, on count two, I will find probable cause to detain you on possession of heroin.
Eric, does he have prior
Possession with
felonies?
intent.
Yeah.
And as to conditions of release.
Yeah, he's
Yeah.
lived in Broward County for 36 years, self-employed, washing cars. lives with his girlfriend, but he does have rent to pay. Currently does not have any money in the bank. It'd be hard pressed to come up with a financial bond. However, through assistance from family, we're hoping if we could ask the court to reduce count 1 to $5,000. I believe that the PC argument, we agreed to $1,000 on count 2. And we'd ask for ROR on 3 and 4.
Your Honor, the state is requesting that the bond, all the bonds be set in place. Just, it should be noted that with GPS monitoring, should be noted that the defendant was released from state prison in 2015. And in addition, his priors, he has a 2005 possession of cannabis with intent to sell, and possession of cocaine with intent to sell. He was sentenced to 60 months. A 2005 aggravated battery, 2005 grand theft auto, 2005 resisting without violence. He was sentenced to 11 years on the aggravated battery and 5 years for the grand theft auto. He also has a 2005 burglary dwelling, sentenced to 11 years, Your Honor. Grand theft, sentenced to 5 years. A 2005 aggravated battery, sentenced to 11 years, Your Honor. 2005 robbery, no weapon, sentenced to 11 years, Your Honor. 2005 robbery, violation of probation, which was sentenced to 11 years, Your Honor.
And Judge, while I do understand the priors that were read out by the state, I'd just like to point out he was released. He has not been in any trouble since his last release. That's been about 3.5 years. That being said, $5,000 is something that he potentially could afford. We're not even sure. I'm not sure that just keeping the bond at $15,000 for money is somehow going to provide a safer community. I think Your Honor should weigh the fact of his ability to post bond with that factor, and we're asking for $5,000.
Okay, I will set bond on count 1 at $15,000. Count 2 at $1,000. ROR counts 3 and 4. And no bond necessary on 5 and 6. Good luck, sir. Davis Curry. Mr. Curry, sir, good morning.
How you doing, sir?
Doing well, sir. And yourself?
All right.
Sir, I do find probable cause to detain you, but your bond's been posted. Gabriel Williams.
How you doing, sir?
Very well, sir. How are you?
Good.
Yeah, so you have 2 warrants for your arrest from 2 different judges, it appears. Let's see, in case number 118047623 TC30A and 18000 CF10A. And on count 1, the bond has been set at $250. On count 2, it's been set at no bond, sir. You have hearings before your assigned judges on 11/26 at 8:30 a.m. and 11/27 at 9 a.m. Okay? Good luck, sir. Let's see. Kimani Brandt.
He bonded, Your Honor.
Okay. Nothing probable cause. He's bonded. Okay, and Jeff Ferrier. Sir, good morning.
Good morning, sir.
One count has been presented. It's possession with intent to sell or deliver or manufacture cocaine. I do find probable cause to detain you. And as to conditions of release,
Judge, he's advised me someone's bonded him out or posting his bond. I don't know if anyone has information in that in the courtroom, but otherwise, it's my understanding he's going to be able to bond out if we leave it as is.
okay. He has an aggravated battery. His bond's been surrendered on, apparently. Well, on this charge, I will set bond at $2,500. Good luck, sir. John Macris. Good morning, sir.
Morning.
Yes, sir, one count of grand theft has been presented. I do find probable cause to detain you, and that's the conditions of release.
Judge, he's advised he's going to bond out on a $1,000 bond.
All right.
This court's finding out probable cause, we ask that his pretrial status be revoked on the pending case.
And that was a misdemeanor criminal mischief?
Yes, it was, Your Honor.
Okay. And defense, state?
Judge, on the case that pretrial mentioned, or you're revoking pretrial but still setting bond? We asked the court to set it at a standard bond for a misdemeanor.
All right. On the cases on the docket this morning, I will, on the grand theft, I'll set bond at $1,000. And on the criminal mischief, I will revoke his pretrial status, set bond at $750.
And Your Honor, we'd just like to add, no return to the victim business.
Yes, no return to the premises, sir. And Tamsin Warren. Good morning, sir.
Good morning.
You have 3 counts have been presented. 1 count of possession of cannabis. 1 count of, possession of heroin. And 1 violation of probation. And on the violation of probation, the bond has been set at no bond, sir. As to counts 1 and 2. And nothing else. Set bond, count 1 at $100, count 2 at $1,000.
Just want to sit.
So it's 1,000 and 100, but it's better than, that way you'll just keep getting credit until you go and see what happens on your VOP, okay? For the, Little?
Yes.
Mr. said your wife was just gonna bond you out,
Yes,
right?
I hope so.
Mr. Mitlow.
Good morning.
Good morning, sir.
Good morning.
And you have one count of obtaining goods with an invalid vehicle title that's been presented. And let's see, I just heard that you're going to have bond posted?
I believe so. I hope so.
All right. Are there any arguments as to conditions of release? Have you heard none? I will set bond at $1,000, sir. Good luck. Romaine Kelly.
Your Honor, we're requesting a photo order for injuries on Mr. Kelly.
Good morning, Judge.
Good morning, sir. I will sign the order. And
Judge, I have an argument.
Okay, you have an argument as to?
Probable cause.
On which count?
That the contempt and the resisting, actually. The contempt being, we don't know if he was approached by, we don't know if he violated the order or if the person who has the order came in contact with him. So we don't know whether or not he actually had made contact with that person or that person was with them. They were at Hoyo Tropical. That's all we know, and there was a disturbance.
Legally, the order would be on the order was protection for that one person.
Mm-hmm.
All it requires is them to be together. It doesn't matter who initiated the contact.
Well, he ran away, so he was trying to get away from him, maybe. I don't know. That's best I got.
Okay. Valiant effort. All right, I will find probable cause. As to conditions of release?
Your Honor, the state would be requesting a $5,000 bond on count 2. The reason being, just so the court's aware, the no contact order that is count 2 deals with stems from a domestic violence felony battery by strangulation against the same alleged victim where Judge Cohen issued the no contact order.
Okay, and I have a feeling that you may file a different charge than what's been presented at this juncture. But for the purposes of this hearing and the charges that have been presented to this court, I will set bond on count 1 at $100, count 2 at $1,000.
Your Honor, we'd ask for
no contact.
Thank you.
I'm ordering no contact with the alleged victim.
And I need my medic.
So no contact means no direct, indirect, telephonic, electronic contact by any means, sir. Be careful what you say at this point because the state may be seeking to file other charges based on this set of events.
Judge, I'd just like to request, in speaking to Mr. Kelly, at this point he's indicating he can't afford that $1,000 bond, Your Honor, setting. He's residing in the Hack and going through the program there, working at Advanced Auto Parts. He's actually supposed to go into work today. He might lose his job. Also, he has some Henderson appointments that he needs to keep up for treatment there. If Your Honor would consider something lower or releasing him on pretrial.
I will respectfully decline that request because I've also declined the state's request to increase based on what they may file at a later time. And I want him to be aware that other charges may be coming just because this is what they presented doesn't mean that's what they're going to file. So I've ruled on what's been presented, not on what may come.
I got the next case. You've got Fontenot next.
And Juan Morales. Juan Ramon.
Morales is approaching. Judge, he declined the public defender's office.
Okay.
Good morning, Judge.
Good morning, sir. You don't have an attorney representing you, and you're not going to have the Office of the Public Defender represent you this morning. Is that correct? Are you planning to hire an attorney?
You're 17?
are you gonna hire an attorney at a later date, sir? Well, just to let you know, you have 3 counts that have been presented. One is you have a warrant for a misdemeanor. The bond has been set at $500. It's for driving the license suspended on case number 170-37916 TC40A. And you have 2 felony violations of probation, one for a possession of alprazolam and carrying concealed firearm on case number 18002060 CF10A, and for possession of alprazolam on case number 18002761 CF10A. And bonds have been set at no bond on those 2 by your assigned judge in the felony case, and at $500 on your judge of the misdemeanor case. So, are you gonna hire an attorney, sir?
No, sir, not at this moment.
Okay, and you're gonna represent yourself?
Right now, I'm going to court right now.
You have hearings on November 26th for your felony and for your misdemeanor on November 27th.
Yeah.
Okay, and 8:30 and 9 a.m. respectively. And all right, sir.
Thank you.
Good luck. Sergio Fontenot.
Bonded, Your Honor.
Maybe some public cause, and he's bonded. Okay. Aaron Davis.
You did that one? That's what
Aaron Davis.
Yes, Your Honor.
And sir, 2 counts have been presented: petty theft, a third of subsequent offense, and resisting without violence. I do find probable cause to detain you, sir. And as to conditions of release,
Did he advise he's gonna bond out on the 750?
state, any arguments?
Nothing further, Your Honor. Just a no return order, Your Honor.
All right, I'll set bond at $750 in count 1 or count 2, and no return. Good luck, sir. Justin Burgess. Mr. Burgess, sir, good morning.
26.
Why would they get me a bond? I wouldn't be able to bond.
6 counts have been presented. Possession of cannabis on count 1, speeding count 2, possession of cannabis count 3, an expired driver's license over 6 months count 4, and then 2 felony violations of probation on counts 5 and 6. The violations have no bond holds, and you have a hearing before your judge on the felony cases plural, on 11/26 at 8:30 a.m. As to counts 1 through 4, any arguments as to conditions of release?
No, Your Honor.
State.
No, Your Honor.
All right. 100 on Burgess. 100 on count 1. No bond necessary on 2. ROR count 3. And ROR count 4. Good luck, sir. Billy Goings.
No problem, Your Honor.
Thank you, sir.
Thank you.
Mr. Goings, good morning, sir.
Yes, sir, Your Honor.
1 count of grand theft has been presented, and I do find probable cause to detain you.
He's asking for pretrial release. He doesn't have the ability to make a monetary bond. He's lived here all of his life, so he's not a flight risk. His mother's on a fixed income. He does have 2 children. He's currently laid off from a landscaping tree cutting business because of a broken hand that he has currently. And my other notes I can't make sense of. Anyways, asking for standard pretrial.
Your Honor, I'd be requesting that the bond be kept in place. Mr. Goings is registered as a Florida career offender by the Florida Department of Law Enforcement. His criminal history includes 2015 grand theft and criminal use of personal identification information. He was sentenced to just over 26 and a half months state prison. He has prior convictions for felony battery, willful fleeing and eluding law enforcement, aggravated assault, possession of cocaine, the two and most recent cases I mentioned, Your Honor. I also show as recently as July of this year, he was picked up on a capias for a failure to appear on 2 separate municipal ordinance cases.
Does he have an address where he can reside?
Sir, Mr. Goins, where were you going to reside?
I'm gonna try to go to a program.
Do you get disability or any benefits of any kind?
No, sir.
Do you have a
Just,
do you have a residence right now?
Food stamps.
Where do you live right now?
I'm homeless, sir.
Okay.
Judge, would you be inclined to place him at House of Hope? Understanding that he's going to wait there until they can accept him at a bed with a bed available.
It would be my order pretrial with a GPS at House of Hope.
Judge. Yes, Judge. Or yes, Ms. Patrice. It will.
Okay, if they don't take him at all, for one reason or another, please bring it back before, I guess there's Malika or whoever's sitting in the seat. Okay.
Your Honor, can I say something?
He has a what?
Your Honor.
Correct. Correct.
You can say something, but keep in mind, everything you say is being
not
recorded.
about the case.
Okay,
Not
thank you.
about
I appreciate it. Some people didn't listen to
No,
me.
I already know that.
Okay.
I'm record, I'm not too fond of. Would ARC be a possibility?
ARC, only if you're not competent to proceed. Are you found not competent to proceed? No, I'm thinking archways. I'm sorry. I don't know.
ARC.
I'm not familiar with ARC, but House of Hope.
It's called the Adult Rehab Center, Salvation Army.
I know that I can get you at House of Hope. I don't know that I can get you there.
Okay.
So, okay.
Okay, all right.
Okay, all right.
Thank you, sir. I just thought it was just option.
And no return. Good luck, sir.
Thank you, sir.
Judge Mangio, we have one more.
Is that Matthew
it's back
Summers?
from page. It's back from page 5.
We have Matthew. The only thing I have left is Matthew Summers.
It was a municipal ordinance case. It's been on recall, waiting for the city attorney, Angel Marte, page 5. I don't know if we want to reset him for this afternoon or what we can do, but he's the only person left here. I don't know.
Well, it's the Hollywood case, if I'm not mistaken. We had Mr. Landere here earlier, and now he's gone. The only problem is, I believe it's a victim case. We don't have the prosecutor here, and the other thing is that prosecutor's from Hollywood.
It's a trespassing in an open container. I mean,
I understand.
I don't know. Do you want him to stay here and wait, or set it for this afternoon? I don't know.
Thought I already ruled on that one.
Your Honor, I thought waiting for
them to. I indicated that I'd readdress it if we did get the prosecutor here, and we did have Mr. Landre here, but no one let me know to bring it to no one brought to my attention to readdress that case at that time. So
I thought it was a different city. But honestly, at this point, he was looking to resolve it, or if he could potentially just be ROR'd on it.
Hold on. It is a different city. What I indicated earlier is that sometimes, and in my courtroom, he will stand in for other cities if he's been given advance notice. I don't know if he was given notice on this one. but sometimes he'll make a phone call.
Judge, I
at this
understand that.
juncture-
I guess my concern is at this point now, he's being sort of punished or set back or set off because of, we didn't call him when someone else was potentially able to stand in. So I don't know, and that's question number one. And number two is, does he sit here and wait to the end of the docket? Can we readdress it this afternoon? Can someone try to call and see what we can do with this
believe I
case?
already
Tomorrow's
ruled on the-
Thanksgiving, and he's sitting in on these municipal ordinances,
believe
and
I
he'd
ruled
either
on the
like to
case.
resolve.
Then
I'm sorry?
I believe I ruled on the case already.
It was
So
my
I
understanding
did
he was
address
placed
it.
on recall. I'm sorry?
I ruled and I indicated that I would reconsider. So
Okay.
I would readdress it if the prosecutor was willing to stand in. That didn't happen, so it isn't, I'm not punishing him for anything. It's just,
Inadvertently, maybe, at this point. I mean, he is sitting in custody on an open container municipal ordinance because he was placed on recall and not addressed when someone was here. I mean, that's,
I find that it would be definitely incumbent upon anyone to let me know if that's a case to address, but if no one.
We don't even represent municipal
Right.
ordinances, so
Right.
how is it our responsibility?
I'm not indicating that it's yours, but I'm not indicating that if someone's asking me to do something, I need the prosecutor here. And if we didn't have that person here, who could potentially stand in, not the one who's assigned. So I've ruled on the case, and
I will just say I've seen routinely these charges get resolved through magistrate court without a prosecutor here in those instances. So in that event, if Your Honor's not inclined to resolve, can we ROR Mr. Marte, because tomorrow's Thanksgiving, these are not serious offenses, it's an open container.
I'm going to address Mr. Summers, and then I'll come back if we have that packet, because I ruled on that one a long time ago. I'll address Mr. Summers at this juncture. I'll come back if we can find that packet. But do we have Matthew Summers? Okay, medical reset.
She's on medical loan.
Thank you. Mr. Linder just informed me. And do we have the packet for the other one? Yes. Thank you.
That's what I'll roll you.
I did set bond, and I'm not inclined at this juncture to change that based on the allegations in the probable cause affidavit. So I'll stand by my previous ruling but I'll be happy to reconsider if the proper parties are noticed. If you can get them in for the afternoon, I'll be happy to reconsider. But at this juncture, based on what I'm looking at now, I do have concerns. So I'll stand by my previous ruling.
Set for tomorrow, Judge? You reset for tomorrow?
On a second look docket?
Regular
We'll put it on tomorrow for the regular docket, okay. Do we have anything left on this morning's docket?
No, I don't believe so, Judge.
Okay.
Judge, what time are we starting this afternoon?
Well, I need to find out, your colleague will let you know, I'll find out how much I have for the afternoon. And
Judge, I'll be out of here, and I gotta advise the jail. They're asking what time to have the inmates brought in,
sooner I
so.
can ask questions, I can answer questions. I don't know what I have, so I can't answer that question for you. I have to make sure that I thoroughly read everything before I address it, so I'll find out in just a moment. That concludes the morning docket. Firing, 1 o'clock.
You want to see Did we already schedule?